Mr. Gonzales, we appreciate your doing this. As you know, there's been a lot of focus here about the Foreign Corrupt Practices Act, and I think one of the questions I've heard asked is, from where you sit, having been in the government and now teaching law and advising companies, if some company came to you today and said, I think we might have an FCPA problem, and we're trying to figure out, do we voluntarily go to justice and deal with these sharp-eyed fraud lawyers in the criminal division? And is that a good strategy, or should we just deal with it ourselves? What would you tell them to weigh if they had to make that decision?
Well, I think that you're better off with voluntary disclosure, as far as I'm concerned. I think you're always better off when you do that. I think we're operating today in an era of great deal of uncertainty, with changes at the criminal division of the Department of Justice. And I think it's fair to say that there's been a great deal of confusion, uncertainty about FCPA prosecutions at Justice. I, for one, looking back at my tenure, generally at the Attorney General level, you're not really involved or focused on FCPA prosecutions. At least I certainly wasn't. President Bush told me to concentrate most of my personal time on terrorism-related issues. But if I had to do it over again, I would probably spend more time speaking with the head of the criminal division and encouraging the head of the criminal division to try to give more guidance, more transparency into the factors that go into prosecution decisions at the Department of Justice. I think for most companies, they're okay. They can take tough sanctions for FCPA violations. What is tough for them is the uncertainty about what kinds of factors the Department of Justice takes into consideration. And so, having to do it over again, I would have a discussion with the head of the criminal division about the importance of being more transparent in terms of the factors that are important in moving forward with the prosecution.
Okay, but if you have the good fortune to be the general counsel or compliance officer of some company, the one thing you can't do is change the criminal division of the Justice Department. So is it in all cases you would say come clean because you'll be rewarded for volunteering? Well, are there circumstances in which you'd say this is going to trigger a whole lot of legal expense and exposure to you that's not worth it? Or is
well, I think that in certain cases it makes sense to do an internal audit to find out, get more information about what exactly has happened here. But certainly, as we all know, one of the factors that is considered by the Department of Justice is voluntary disclosure. Look to see whether or not has the company implemented some kind of compliance program. Has the company complied with that compliance program? Has there been any kind of involvement at senior management? Once you discover whether or not a problem arises with respect to the FCPA, have you done an investigation? And so these are the kinds of things that I think that are important. From my perspective, I think it's important to know what's going on within your company and to do an internal investigation, but I think you're better off doing some kind of voluntary disclosure at the appropriate time.
And how do you decide whether the time is appropriate?
Well, that's a very tough question. It seems to me that the appropriate time is to know exactly what has happened, to understand what has gone right, what has gone wrong in terms of within the company, and that you can present a credible explanation to the Department of Justice about what you've done to minimize exposure, to minimize problems within the company relating to FCPA violations.
Now, it's pretty clear what the motivation for the FCPA was. We have decided that it's not cool for American companies to bribe foreign officials. Do you think that the FCPA actually is serving that end? Or has it become this kind of, I have this idea of it's some kind of Rube Goldberg plumbing where everybody's going around trying to figure out is this legal or not, and we've kind of lost sight of the end point, or am I being unfair? I think
it's hard to tell, quite frankly, because I think that there are many companies today entering into non-prosecution agreements, these alternative dispute methods for activities that, quite frankly, don't violate the FCPA, but companies feel pressure to do so. And the other problem with these alternative resolutions is, of course, is that legitimate wrongdoing, quite frankly, isn't being prosecuted the way that it should. So I don't know if I can answer your question in terms of achieving the objective. I think from the department's perspective, sometimes the focus is more on the numbers. How successful have they been in achieving prosecutions, the amount of dollars received through fines and penalties, as opposed to, I think, what the true objective should be, which is to discourage unlawful activities relating, for example, such as bribery of foreign officials.
So if you were advising Congress or the Attorney General on how we ought to rethink this, were there reforms you think we ought to do, or guidance we ought to give, or changes to the law we ought to make?
Well, business groups have certainly been clamoring for additional guidance for many years. And of course, as we all know, last fall, the Department of Justice issued so-called guidance, although Lanny Breuer was very clear in indicating that there's no change in policy. I think, as I said, more transparency is important. I don't see it coming, quite frankly, changes from Congress. Certainly not during this administration, and so long as you've got this president in the White House and I think the Democrats controlling Congress, controlling the Senate, I think it's going to be the status quo, quite frankly. And the question is whether or not we can get some additional guidance or changes at the agency level, at the SEC, and of course at the Department of Justice. And I salute the efforts of business groups. There was a letter written earlier this year to both enforcement agencies asking for additional clarification, additional guidance. And so the fact that the department came out, that the government came out last fall with so-called additional guidance, as far as I'm concerned, does not end the need for additional discussion about this. I think it's very, very important for business groups to continue to approach the agencies and continue to ask for additional guidance. For example, one of the things that would be very, very helpful is to understand the reasons why our enforcement agencies decline to prosecute certain kinds of cases. I read from my friend George Twilliger that asking for the possibility of a year-end report that's been anonymized so that we don't protect the identity of the players, but that itemizes the factors that the enforcement agencies take into account when they make a decision to decline to move forward with the prosecution.
And if if a corporate executive came to you and said, look, I don't think I have any bribe problems, I sure hope I don't, or I did have them, but they were 10 years ago and we fired that guy, but I'm trying to create a climate in my company where people understand that this isn't only unlawful, it can get the company into a lot of trouble, but it's not a good practice, not a good idea. What advice would you give them about what to say to their employees?
I think putting in place a rigorous compliance program is important. Putting in place training, periodic training, reminders, I think is also very important. And I think that this is instill a culture of non-tolerance at the highest level within the company is something I think could make a difference with respect to decisions by enforcement agencies when a problem does arise. Because even with those kinds of protections, you still may have a rogue agent, a rogue employee somewhere in a foreign land that does something they shouldn't do, and it's going to be helpful to some degree if you've instilled or tried to instill in that company a culture of non-tolerance and understanding of what the law requires.
Talking about culture, we're sitting here in Washington, which has a peculiar culture that you had a lot of experience with, and as I recall, you were at the White House counsel's office and at the Attorney General's seat during a particularly tumultuous time in our history, 9/11 and the war on terror and so forth, and you certainly took your share of arrows when you were here, the questions about how U.S. attorneys were hired and fired and all that stuff. And you have a little bit of perspective on that. You've not only left Washington, you've left Texas, and you're now living in Nashville. And I wonder, when you look back, would you advise one of the people in this room to come take a job in Washington, given everything you went through?
In a second.
Really?
I would do it again in a second. It's the hardest thing I've ever done, but also the most rewarding thing I've ever done. To really make a difference, it's why I became a lawyer, and I suspect it's one of the primary reasons that all of you who are lawyers got into the legal profession, to make a difference. I was blessed with a unique opportunity to work in the White House for 4 years and then to work at the Department of Justice for almost 3 years. But as I travel around the country and I talk to law students about the importance of public service, which I believe in very deeply, I emphasize that to go in with your eyes open and your armor on, because it is tough. I don't know if it should be that hard, quite frankly. It discourages good people from serving, and things aren't going to get any better unless we have good, intelligent, strong-willed individuals who are willing to step into the arena of public service and serve the American people. So yes, without question. Now, my wife would say absolutely not. We would not do it again. Because it takes a tremendous toll on the family, and particularly on the spouse. My spouse read every negative thing written about me. I tried to read none of it, but she tried to read everything, and it's just very, very tough. But I think going into that public service will make you a better lawyer in what you do today when you go back into private practice, but it will surely make you a better person. I have no question about that.
And in terms of, if you were, I mentioned what you said with your eyes open and your armor on. So if someone came to you and said, I'm taking one of these jobs, what do you mean by eyes open and armor on?
I think the Texans in particular, we were naive in 2001 when we came into office. I served with Governor Bush in Texas and saw how he successfully worked with Democratic leaders in Texas to get things done. And I think we had the expectation the same thing would happen here in Washington. Obviously, everything was sort of diverted. The train kind of went off the track after 9/11. Priorities changed. And for a period of time there, I think the country was unified in terms of responding to that attack. But quickly, over a period of time, partisanship returned. And I think that's very, very unfortunate today. You know, as I spend time away from Washington, I realize that this is not the center of the world. This is not the center of the universe. Most Americans don't know, and quite frankly, don't care what's going on here in Washington on many levels. But yet, it's so important, the major decisions that occur here at the federal level. But we were talking earlier about the feelings I have whenever I come back here, such mixed feelings about the good times, the things that we were successful at achieving, but also the difficult times. And I worry about the lack of progress. The perception outside of Washington is that really this government is broken. And I think it has a lot to do with the fact that, listen, our founding fathers put in a system of checks and balances, which was intentionally, it was intended to make certain decisions difficult. But when you add on top of that partisanship, it really frustrates any kind of progress. What I worry about today is it appears to me is that people don't really like each other. And when you don't like someone, it's hard to reach an accommodation. You don't want to reach an accommodation. And I don't know what the remedy for that is, quite frankly. I often say that in my time in Washington, I met a lot of politicians. I met very few statesmen. And by statesmen, I mean people who care more about the next generation than they care about the next election. Just don't exist here in Washington. And part of that, unfortunately, I'm going to point a finger at myself and you all, and the population. The American people insist that their representatives adhere to certain strict policies, and if you compromise in any way in Washington, you're punished during the next election. And we're not electing the right kind of people who are going to say, I've got to do what I think is the right thing to do, irrespective of whether or not it costs me my job at the next election.
We're going to turn to questions in a minute, but I want to ask you something about your expertise, which has nothing to do with the FCPA. You were, of course, at the Justice Department when a lot of decisions were made about the war on terror. John Yoo worked for you. And right now we have an issue, I think, which is just fascinating and of enormous importance. And really the question has to do with the power of the president to embark on targeted killings. Did the Congress mean to give the President of the United States the power to take a drone and send it somewhere overseas and kill somebody who may or may not be an American citizen? And as you know, there's been a lot of second thinking about this right now, and I'm curious how you see it. Should we change the law? Is there room for judicial oversight? Should we be doing something different here?
A couple of points before I respond to the question. First, John Yoo never worked for me. He worked at Justice when I worked at the White House. Two, I'm a big proponent of executive power, commander-in-chief power, to protect this country in response to an imminent attack and in self-defense. So I think that record speaks for itself. If I had been advising President Obama about al-Awlaki, the American citizen killed a couple of years ago in Yemen, who had advocated all kinds of terrible things against the United States, and by press accounts became operationally involved in certain activities, I would have told him, Mr. President, this American citizen is an enemy combatant, and you do have the authority to take him out. However, Mr. President, I don't know that there are 5 votes in the Supreme Court that would agree with that assessment, that you, the President of the United States, would have the authority on your own to say that al-Awlaki, an American citizen, is an enemy combatant. And the reason for that is cases like the Hamdi case before the U.S. Supreme Court, where the U.S. Supreme Court said the President on his own doesn't have the authority to determine that Hamdi is an enemy combatant without giving Hamdi the opportunity for notice, an opportunity to rebut the charges against him before a neutral decision maker. And that's in the context of detaining an American citizen. What would the court require with respect to killing an American citizen? So I think once you're validly designated as an enemy combatant, the President should be free without any kind of consultation with Congress or the courts to take you out, just like you would encounter someone on the battlefield as an enemy combatant. But the question is whether the President on his own can say an American citizen is an enemy combatant without giving that American citizen some level of due process. And I understand the Obama administration went through a period of months of review and assessment as to whether or not al-Awlaki was an enemy combatant. And that's good news. The bad news for the administration is that a court may say, well, wait a minute, if you've got months to make this calculation that al-Awlaki is an enemy combatant, then we have time to give him some kind of process, due process. What that would look like, I don't know. The court in Hamdi said we have to be respectful of military necessity, and so an American citizen would not be entitled to the same level of due process you would normally receive. You would be able to take into account military necessity, would allow hearsay evidence, for example, would allow possibly the neutral decision maker to be a military tribunal. And so I don't know what that would look like, but I think looking at the cases, it is clear the President of the United States, while he has substantial commander-in-chief authority under the Constitution, is always stronger when he acts with the support of congressional legislation. And so that may be one thing that Congress should do, is look at passing legislation to supplement the President's constitutional authority. The problem is, of course, no President wants to invite Congress to do that, because once Congress gets involved, who knows what's going to come out of that. Things often get political, things often get delayed, and quite frankly, oftentimes discussions happen, debates happen in the open field where classified information may be compromised. So that'll be a delicate balance as to whether or not the administration, how much it's going to want to have some kind of congressional support.